Welcome back to OpenLine. Talking with Tim Takis about all manner of things, elder law planning, and we were talking about trusts.
Yes.
As we went to the break.
Right.
Taylor had a call, and revocable trusts.
Right.
So,
and the essence of it is it's revocable, which means you can change it at any time. You're going to say, no, I don't want to do this. I want to change my beneficiaries of my trust. So when I die, I don't want to leave it to my 3 children. I want to leave it to somebody else. Or let's say one of your 3 children becomes disabled. You can change your trust, you know, so that you have a special needs trust maybe in there for that child, or maybe a grandchild is born that has special needs, or you got to do something else. It's an estate planning document that basically it's a bypass of a probate thing. You know, now, what are some other reasons that we might want to have a revocable trust or a trust? One of the things that, you know, I'll just tell you about a situation of clients that came into my office today to talk about their estate planning for the first time, and it's like late 50s, and they're going, okay, the last will that they did was like 28 years ago.
Right. Okay,
and I said, well, you know, it's not too late. You know, they said, we really know we need to change this because, you know, now their children are like 30 or 32 or whatever it is, and one of them lives in Kentucky, another one lives in Florida, you know, and, you know, or someplace like that, and now they're going, you know, well, both of the sons, you know, did not marry well. You know, so it's like 2 sons, and they're going, well, I don't think our sons married very well here. So what they did, and they knew that their sons needed help so they bought houses for their sons. Oh. The ones in Kentucky, you know, but the sons are paying the mortgages, and the names of the houses are in their parents.
Wow.
Okay. Wow. Okay. Now, here's the 2 sons, and one of them is married and one of them is not now. One of them had already been married, you know, and it's like, okay, they're paying a mortgage on property they don't own. Now, if I'm them, I'm going, now wait a minute, I'm writing checks to the mortgage company on property I don't own. Well, yeah, I mean, we do that every day if you rent property. You know, but the idea is that the intention for my clients is they want their children to get those properties. So one of the things that I'm going to do in that case, as I explained to them, is that, okay, you live in Tennessee, but if you own property out of state, then you're going to have a probate in each state. You are a non-resident of Florida, you are a non-resident of Kentucky, you know, and if the 2 of you die in an automobile accident, you know, and now you got a probate, you know, there's going to be maybe there'll not be a probate in Tennessee, but how are you going to get that property over to your children in Kentucky, you know, in Kentucky and Florida? There's going to have to be a probate. So if we put those properties into a trust, you know, and mom and dad pass away, you know, then the trust would then say, well, at the death of the survivor of us, the trustee will deed out this property, you know, to this child. No probate.
Right. It's just very clean.
It's very clean. You know, so at the very least, you know, when people walk into our office, you know, and they fill out their workbook and we see that they own a piece of rental property in Colorado or a vacation home in Florida, you know, the ding, ding, ding goes off in our heads and going, well, you know, guess what? You know, if you really don't want to go through probate, you know, we don't want to do 2 probates, we don't want to do any. But even if you don't do a probate in Tennessee, you're going to probably have a probate in Florida. And you certainly don't want to do that. You know, so how do we avoid that? And that's the kind of things that we look at, you know, is why do we need to do this? Well, there's some good reasons why.
And how complicated in your office do wills get? Do they get pretty complicated? Because you've explained on this show how they're pretty simple.
They can be really simple.
You know, they can be really simple. And some people, you know, they obsess over these things, but wills can be pretty simple. But I guess if it comes down to how much do you want to control, then they can be pretty complicated.
Yeah. And a lot of times it's, you know, when we start thinking about control, you know, there's always those people out there that, you know, okay, they do what sometimes has been referred to as like some sort of, you know, multi-generational trust or whatever, which says, you know, when I die, I want to leave my property to this trust, you know, and the trust will terminate at the death of my great-great-great-grandson or whatever it is, who's not born yet, you know, or whatever. And now you've got a trust in place that could be like for decades.
Could you ever override that?
Well, I guess you. I guess you could, but I don't think it would be. I think it could be difficult to do.
That's very interesting.
Yeah. You know, you can literally, by state law, you can have a trust that's in existence for 360 years. Wow. I mean, there are limits on that. Now, that used to be a much shorter period of time. Mm-hmm. You know, there was what's called the rule against perpetuities. You know, which was like an old common law rule, which, you know, for people who have ever watched, you know, people who are movie mavens out there will know that that was the plot device in the movie Body Heat.
Okay.
Came out in the 1980s with Kathleen Turner and William Hurt. Mm-hmm. You know, he was like some small town lawyer that, you know, he messed up the rule against perpetuities or whatever, and that was like it was really kind of. But anyway, I mean, that's just like me digressing. But the whole point is that, I mean, you can use a trust to rule from the grave, and that's part of what we talked about today with this the husband and wife, and I talked about that, and and the husband said, one of the things that we really don't want to do that. It's not their job to be helicopter parents.
Right.
When they're when they've been deceased for you don't know what's going to happen.
Yeah, that seems okay. Let's go to Sherry here. Sherry, hello.
Hello.
Hi. What's on your mind?
My question is this: my brother and I don't have children, and we don't own property. But we were thinking, around the bend we might go to heaven, and we'd like to leave things to someone. A friend of mine lives in Ohio, and we're thinking about leaving our contents of our apartment to her, and trying to figure out, do I need a will? Do we both need a will so that we can leave our assets to someone and protect what is in the apartments so that she can come get it?
Okay, so what Sherry is telling us is that she and her brother don't own any real estate, and they have no children. And they're going, okay, well, in the event that we pass away, how do we make sure that the personal property gets to the people that we want it to get to?
Right.
And I know I've talked about this before on the show. It's been a while. Is that I have, from time to time, I have people that walk into my office and have old wills, and almost invariably, the lawyer will put something in like, well, I leave the antique sewing machine, to, my great-granddaughter, or my granddaughter, and I leave the moon rock, to my, my grandson, or some sort of thing, and what happens is personal property goes away. Mm-hmm. I mean, I have people that say, well, I leave my, 2014 Toyota or whatever it is, and unless it's like an antique vehicle or whatever, but why would you do that? Because, so stuff like that is what I call ephemeral. It comes and goes.
Right.
So what we want Sherry and people, and we always tell people, we say, we don't do that in our documents. If you ask me to say, well, write all that stuff in, I want this item to go to this person, this item to go to this person, I say, no, time out, we're not doing that. It says, because sure enough, you're going to be dead in 10 years, and someone's going to look for that, and they're going to wonder why didn't I get it? And it's going to, and then they're going to find out that their little brother has it, and the little brother's going to say, well, Mom gave it to me, and then the older brother, older sister says, well, I was supposed to get it. It says right here, well, no, she gave it to me, and then the way you go, you have a dispute.
That's interesting. Yeah, that would create it.
So what you do is we tell our clients is, you've heard the ultima thing, the shortest will, you write it out in your own handwriting. You do the same thing for personal property.
And her friends in Ohio, she would just say all to her friends.
Yeah, and she says, she lists the items, and she says she signs it and dates it, and maybe she sends a copy of it to her friend and says,
she has it.
So she has it.
Okay, there you go. We'll take a break. Be back right after this.